was what is really the effect of the 2015 amendment to court proceedings arising out of arbitration. Now, you all are all aware largely about the journey of arbitration law in India, which started with the 1940 Act, and the 1996 Act was brought in to bring it in line with the ancestral model law, with the hope that the Act will bring down judicial intervention in arbitrations in India. But over a period of time, the kind of judgments and various judicial pronouncements which came in India, they defeated the purpose of the 1996 amendment, and gradually in various fields increased judicial intervention, and in some fields it caused utter chaos. So over a period of time, from the experience of the 1996 Act, various attempts were made to bring about amendments to the Arbitration Act. Ordinances were made, committees were framed, but the final culmination of that came in 2015. Now, there are very few legislations that I've found in India, particularly legislations of commercial nature like the Arbitration Act, which have been subjected to so much of judicial scrutiny in such a short time. The Arbitration Act came in 1996. And between 1996 and say 2005, 2006, we had a situation where a single topic under the Arbitration Act underwent judicial scrutiny by 3-judge bench, a 5-judge bench, and finally resting with a 7-judge bench. I mean, imagine a 7-judge bench of the Supreme Court sitting and trying to decide issues on the Arbitration Act. And that led to many conflicting judgments, many judgments which led to a situation that the Arbitration Act effectively was rewritten. So the 2015 Act was a result of the Law Commission report headed by Justice A.P. Shah, was an attempt to try and reduce the judicial intervention, and also to try and bring about to try to undo the effect of a lot of judgments which were passed earlier. And therefore, the 2015 amendment really had 2 or 3 effects. It had the effect of trying to encourage institutional arbitration in India. It had the effect of trying to reduce judicial intervention in India. And it primarily also sought to undo the effect of various judicial pronouncements. And that is very clear from the various provisions of the amendment, which in fact goes to say that notwithstanding any judgment to the contrary, so they expressly tried to overcome judgments which were passed by the Supreme Court in various matters. Now, if we consider the scheme of the 2015 amendment in light of court proceedings, let us divide it into, say, pre-arbitration intervention, during arbitration intervention, and post-arbitration intervention, and how the 2015 amendment has tried to streamline, and 2015 read with the 2019 amendment, have tried to streamline the court proceedings and to reduce intervention in that. So one of the first provisions about reducing, the intervention of the court in arbitration matters before the commencement of arbitration is the provision of section 11 relating to appointment of arbitrators. Can we have some, I think some of the phones are not on mute. Just have it on mute so that, we don't have this disturbance, please. Thank you. So section 11 was one of the provisions which was often litigated upon, and this was the matter which led to a 7-judge bench of the Supreme Court, where there was a great deal of dispute whether the function of the court was administrative or judicial. There were, as you all aware, there are conflicting judgments in Rani Construction, then Konkan Railways, leading to SBP Patel Engineering, which said that the function of the Chief Justice or the nominee of the Chief Justice, in the section 11 prior to the 2015 amendment, the power to appoint was vested in the Chief Justice or the nominee of the Chief Justice. And SBP and Patel Engineering virtually rewrote Section 11 in a great number of matters. It held that Section 11, the Chief Justice exercised a judicial function. It also expanded the scope of inquiry under Section 11 and provided that before appointing an arbitrator under Section 11, the court will go about considering various issues, including the limitation of the claim, whether the claim was a stale claim, whether the dispute was arbitrable, and a whole lot of other aspects. And it even went on to the extent of saying that if required to arrive at a conclusion on these issues, the court was entitled to lead evidence. Now, this defeated the entire purpose of Section 11. What was the purpose of Section 11? If there is an arbitration agreement, usually the parties should constitute the tribunal themselves. The idea of a Section 11 was that if parties cannot consent to an arbitrator, then the court should constitute the arbitral tribunal, and thereafter the party should go to the arbitrator. Now, this was the realm of Section 11 as it was originally anticipated and as has been the international scheme. But that was expanded under Section 11 by SBP and Patel Engineering. Now, this was sought to be undone by the 2015 amendment. Now, SBP and Patel Engineering, as you all know, was sought to be diluted by subsequent judgments of the Supreme Court, etc. But in 2015 amendment, it was clearly, now all those provisions were made very clear. The function was now clearly given to the High Court and Supreme Court instead of the Chief Justice of the High Court and the Chief Justice of the Supreme Court. So the function now vested, the power of appointment vested in the High Court or the Supreme Court. So High Court in relation to domestic arbitrations and the Supreme Court in the context of international commercial arbitrations. Secondly, the most important provision, change which was brought about by the Arbitration Act of 2015, the Amendment Act, was the introduction of Section 6A, which said that while appointing an arbitrator, the court shall consider only whether there exists an arbitration agreement. So the court will really go into only the existence of the arbitration agreement and nothing beyond that. That's main thrust of Section 6A. And there were also various other provisions that a Section 11 petition should be disposed of within a period of 60 days. Thereafter, there was also a provision that the order passed appointing an arbitrator is not subject to any appeal before any court. And these were all provisions introduced to undo the effect of SBP and Patel Engineering and to reduce the scope of inquiry under Section 11 so that the tribunal can be constituted expeditiously, and thereafter the party should be left to raise all contentions before the arbitrator, including issues under Section 16, whereby they could argue various issues apart from the issue of existence of the arbitration agreement. So this was the purport of Section 11(6)(a), and this was in fact clarified by the court, and the Supreme Court confirmed that the inquiry under Section 11(6)(a) is a very limited inquiry, only restricted to the existence of an arbitration agreement. And that two judgments of the Supreme Court are in the case of Duro Felgura and the judgment in the case of Mayawati. The citations you all will find in the note circulated by me, which link is already there in the note circulated in the invitation to the Zoom. So Duro Felgura and Mayawati clarified that while appointing an arbitrator, the scope of inquiry of the court is only to consider the existence of an arbitration agreement. There is a judgment of the Supreme Court in the case of Vidya Drolia, which says that whether a dispute is arbitrable or not, whether that would fall within the ambit of the inquiry as to the existence of the arbitration agreement or not, is something which needs to be considered by a larger bench. So therefore, this issue is at large. So suppose, let me give an example. Suppose in a landlord-tenant dispute for recovery of rent, there is in an agreement, there is an arbitration clause. Now, there is arbitration agreement exists, but if you were to file a Section 11 proceeding in the court and say that I want the appointment of an arbitrator, that dispute per se is not arbitrable in light of the judgment of the Supreme Court in Natra Studio and various other judgments. Now, is the court still bound to appoint an arbitrator under Section 11(6)(a) because there exists an arbitration agreement? That's an issue which the Supreme Court says needs to be decided by a larger bench. This issue was broadly gone into by Justice Patel in relation to a TRAI matter, where it was considered whether such a dispute inquiry can be gone into, whether the dispute is arbitrable or not under Section 11(6)(a). And Justice Patel has gone into it and said, ex facie, if the dispute is not arbitrable at all, then the court may decline to appoint an arbitrator. But if there is any element of dispute on that which requires a detailed inquiry, then that should be left to the arbitrator to decide. Now, one of the judgments of the Supreme Court holds in Rashid Raza seems to suggest that an issue of fraud can be gone into at the time of appointment of an arbitrator. Now, as I said, there are so many judgments of the Supreme Court which lead to such conflicting views. Now, if there is an issue of existence of an arbitration agreement, then the issue of fraud, I would believe, should usually be left to the arbitrator to decide. That it is for the arbitrator to decide that does it involve such complex issues of fraud that according to the arbitrator, this is not arbitrable? Because that again, it requires an inquiry beyond the existence of an arbitration agreement. Now, one of the most important judgments, as you all are all aware, under the new Act and under Section 11 is the requirement of stamping of the document in which the arbitration agreement is incorporated. So what happened was, under the earlier Section 11, there was a judgment in SMST which said that unless the document in which the arbitration agreement is embedded is stamped, adequately stamped, till that time, the court cannot appoint an arbitrator under Section 11 of the Arbitration Act. Now, after the new Act came in, there were a series of judgments, including a judgment of the Bombay High Court, Justice Kulabawala's judgment, which held that in light of Section 11(6)(a), it was not necessary for the court to go into the issue of stamping at the stage of appointment of an arbitrator, because the court was only considering the existence of the arbitration agreement. Now, there were conflicting judgments of Bombay High Court, and this was referred to a larger bench. And the larger bench of the Bombay High Court, a 3-judge bench, held that in light of Section 11(6)(a), the issue of stamping was not required to be gone into. But just 2 days after the full bench judgment of the Bombay High Court, as you all are aware, the judgment in Garware-Waldrop came in. And that just referred to the Bombay High Court full bench judgment in a single sentence, but it did not, in a sense, it was not bound to deal with it, but it did not go into the reasoning given by the Bombay High Court. But what in effect Garware-Waldrop held in the context of Section 11 was that the court had no power to appoint an arbitrator under Section 11 if the arbitration agreement is embedded in another document which is not adequately stamped. And while doing so, Garware-Waldrop made a passing, or rather not a passing, but in fact an observation that till this time the document is stamped, the agreement does not come into existence. And if the document is not in existence, then the court cannot appoint an arbitrator on that basis. Now, I personally have always had an issue as regards this stamping issue and the view taken by different courts that the document needs to be stamped. So let's take a simple example. Can we just mute the things? Let us take an example. An arbitration agreement as defined in Section 7 includes an exchange of correspondence. So suppose we were to write an email to one another. If I were to write an email to you saying that I'm ready to refer this dispute to arbitration, and you respond back to me saying that I'm fine with this. Now, that can constitute an arbitration agreement, but that doesn't require a stamping, because the fundamental principle always was that an arbitration agreement is an independent agreement which is embedded in the other document. But it is a severable agreement, and it is merely because it finds place in another agreement doesn't mean that that agreement doesn't have an independent existence. So to that extent, I would believe that, but my belief doesn't matter much because the Supreme Court has already held that. But since we have, put this topic as a critical analysis, I'm doing my little bit of analysis to say that if letter correspondence can lead to an agreement, then I don't see why arbitration agreement, then I don't see why the stamping of the main transaction document is relevant for the arbitration agreement, because an arbitration agreement can very well be a separate document. What happens if we start drafting a separate arbitration agreement independent from the main document? Should consider that in future we should have a separate document also for arbitration agreement, which is merely an arbitration agreement that doesn't require a stamping. So where does that lead to? So these are issues which now, of course, are of academic interest because the judgment Garware Walrop is already a binding judgment. Now, one of the important issues which arose is that whether Section 11 application, there is a period of limitation applicable. The general view prior to the 2015 amendment was that the limitation for a Section 11 proceeding commenced after 30 days of invocation of the arbitration agreement. And that is because the cause for filing a Section 11 proceeding arises only after you invoke the arbitration agreement in relation to a dispute, and the other side fails to appoint or agree to the appointment of an arbitrator within 30 days of such invocation. Only then the cause for filing a Section 11 proceeding arises. Before that, it is premature. And there were a series of judgments earlier which held that the limitation of the main claim is very different from the limitation of the Section 11 proceedings. But one judgment of the Supreme Court in the case of Geo Miller, which came after the 2015 amendment, and the observations made by the Supreme Court in that judgment led to a great deal of confusion, because that judgment seemed to suggest that the limitation for a Section 11 proceeding application would start simultaneously with the limitation for the claim. So what effectively that judgment seemed to suggest was that if your claim is barred by limitation, that even your Section 11 proceedings are barred. Now, while doing so, that bench of the Supreme Court did not notice earlier judgments of the Supreme Court in any case. There were various other judgments of the Supreme Court which had held otherwise, but those judgments were not noticed. But in any case, the Bombay High Court has now distinguished that judgment and said that in that case, the facts were very different. And in that case, the proceedings in the High Court were prior to the 2015 amendment. And in that light, the court has distinguished that judgment. There are two judgments of Bombay High Court. One is a judgment of Justice Patel, and another is a judgment of Justice Kulkarni in Marvel Realtors, which has distinguished these issues and said Geo Miller does not bring a change to the situation, that the limitation for a Section 11 proceeding commences after 30 days of invocation of the arbitration agreement. So that is the position now. Geo Miller has been distinguished. So as I said, over a period of time, there have been a lot of conflicting judgments under the Arbitration Act and in quick succession. And that leads to a situation which have required amendment, but every problem, every judicial decision, we cannot keep having amendments to the act to keep meeting judicial decisions. So that's something which we need to bear in mind. Then we come to the second limb of intervention prior to the commencement of arbitration proceedings. And that is a reference to arbitration under Section 8 and Section 45. In this also, there were a series of judgments earlier. There was a judgment in the case of Sukanya Holding, and there were a judgment. Before we go to that, it is important that under Section 11, the Law Commission had advised that the inquiry by the court should not only be on the existence of the arbitration agreement, but also on the aspect whether the arbitration agreement is null and void. But that part of null and void has been excluded by the Act. The Act did not accept that part of the recommendation of the Law Commission and had only accepted the part regarding the existence of the arbitration agreement. So that also reflects on the legislature's intention of a very restricted inquiry under Section 11 of the Arbitration Act. Now, one more thing under Section 11, the 2019 amendment now has virtually permitted transferred the power of appointment of arbitrator from the courts to arbitral institutions, but that part of the Act has not yet been notified. And since now the arbitral institutions are to appoint the arbitrator, Section 11(6)(a) is also deleted, because if there is no court, then the institutions are not supposed to do much of an inquiry. They will see an arbitration agreement, and then I guess just nominate the power to nominate an arbitrator has been vested with the tribunal, and thereafter parties can go and raise all contentions before the arbitrator. But none of these provisions have yet been notified, and therefore they have not come into effect. So coming to Section 8 and Section 45, which are provisions that if there is a judicial proceedings in relation to a dispute which is covered by an arbitration agreement before a judicial authority, then it is open to the defendant, who is a party to the arbitration agreement, to make an application to court to refer the dispute to arbitration, or refer the parties to arbitration. That's the wording, not the dispute to arbitration, but to refer the parties to arbitration. Now, there were also a series of judgments under this where there were a problem. There was Sukanya Holding. Then there were a series of other judgments. There were Chloro Control, which said that, claiming by, under, and through and connected parties. A lot of other issues were decided under Section 8, etc., Section 45 there. Now, the 2015 amendment, the Law Commission had suggested a means of getting out of Sukanya Holding's judgment. The judgment of Sukanya Holding was that unless the entire dispute and all the parties to the dispute are covered by the arbitration agreement, till that time, the dispute cannot be referred to arbitration. So very often, to avoid the arbitration agreement, people started impleading not necessary parties as parties to the suit, who are really not germane to the arbitration proceedings, who are being impleaded as defendants, so that a contention could be taken that these defendants are not a party to the arbitration agreement, and therefore I cannot go to arbitration. The Law Commission had suggested an amendment to say that merely because certain parties who are not so necessary have been impleaded, that does not take away the power of the court to refer parties to arbitration. But that suggestion of the Law Commission was not incorporated in the Act. But there are ways and means of it. Those defendants can make a 711 application there, but the whole process gets delayed. But this part of the Law Commission report which was an attempt to undo the judgment of Sukanya Holding, was not incorporated in the Act. Section 8 clearly says an important provision, notwithstanding any judgment to the contrary. And to bring about a element which was tried to be incorporated in the Act by chloro control, Section 8 now also enables the court not just to refer parties to the agreement, arbitration agreement to arbitration, but also parties claiming through or under them. So suppose there is an agreement between an owner of a property and a purchaser, and whereby the owner of the property agrees to sell the property to somebody else. And thereafter, the owner of the property sells the property to another person. Now, earlier you could say that this person who's purchased the property is not a person who was a party to the arbitration agreement, and therefore any claim by the purchaser of the property against this person cannot be referred to arbitration. But now it may be possible to say that he is a party claiming by or through, under or through the owner of the property, and therefore that can be referred to arbitration. Now, one very important difference between the recommendation of the Law Commission and the Act of 2015 is this. The Law Commission had suggested that when a Section 8 application is made before the court and the court finds that prima facie an arbitration agreement exists, a valid arbitration agreement exists, then the party should be referred to arbitration. But if the court finds that the agreement is null and void or the agreement does not exist, that has to be a conclusive finding. So what the court really said was that if you were to reject a Section 8 application on the basis that the agreement does not exist or that the agreement is null and void, that should be a conclusive finding. So effectively what it meant was you should try to refer parties to arbitration, but otherwise to not refer parties to arbitration, you must arrive at a conclusive finding that there exists no arbitration agreement or that the agreement is null and void. But the 2015 amendment has used the word that the court will refer parties to arbitration unless the court prima facie finds that no valid arbitration exists. So even on the basis that of a prima facie finding that no valid arbitration agreement exists, it is open to the court to decline the reference to referring the parties to arbitration. So this is a situation, this is not an issue which has been gone into at length by any court, but this is a point which will have to be considered as and when an occasion arises, that on the basis of a prima facie finding that no valid arbitration exists, the court can reject a Section 8 application or a Section 45 application. So this is something which will have to be considered as and when more of Section 8 and 45 are considered within the realm of the new Act and these issues arise. There is a similar amendment under the section Section 45 of the Arbitration Act. After the 2015 amendment, Justice Sri Krishna committee was formed, the Law Commission, and they made a suggestion to amend Section 45 in a particular line. But that suggestion was also not incorporated as suggested. And instead, there is an option to, just give me one moment, there is an option to decline the reference to arbitration on the ground that the prima facie no valid arbitration agreement exists. So that's again a conflict between the Law Commission report and the, if you all see paragraph 41 of my note, in Shinetsu, the Supreme Court, in the context of Section 45 of the Arbitration Act, taking a purposive interpretation, suggested that the examination of 45 of the Arbitration Act only required a prima facie finding that the arbitration agreement was valid and not null and void, inoperative, or incapable of being performed. In a concurring judgment, while agreeing that a prima facie conclusion had to be arrived at, the court held that when the court refuses to refer parties to arbitration, it would be required to conduct a full trial. So that was the recommendation of Justice A.P. Shah's committee also in the 2015 amendment. Now the same thing was Justice Sri Krishna committee also tried to bring about this clarity and also sought to bring about a consistency between section 8 and section 45. And it recommended that section 45 be amended to clarify that the court shall refer parties to arbitration on the basis of a prima facie conclusion that the agreement is not null and void, inoperative, or incapable of being performed. However, the 2019 amendment only clarified that the court will refer parties to arbitration unless it prima facie finds that the agreement is null and void, inoperative, or incapable of being performed. So the provision has really been turned on its head. On a prima facie finding that the agreement is null and void, inoperative, or incapable of being performed, the court can reject a section 8 or section 45 application. So this is a situation which goes against the general principle of promoting arbitrations, and to say that the endeavor should be more to refer parties to arbitration. And if you are taking any step which is preventing the parties to go to arbitration, or whereby you're not compelling parties to go to arbitration, then it is then you must arrive at a conclusive finding. I'm not going into the chat because it is not possible for me to go into it simultaneously. If there is any query, then we can see that. Okay, there are long queries, so it is very difficult to comprehend. And let's see at the end of it all, if we can have a question answer session, then maybe you can try and have a discussion, and I also get to learn a little out of this whole exercise. Now, this is the broad ambit of section 8 and section 45. We could go on and on, but we also have a limitation of time. We all are already late today in the starting of this, so I'll try and make it faster. Then the next provision is section 9, which is a provision where the intervention of the court can be before the arbitration and also during the arbitration, and to some extent maybe afterwards also. Now, section 9, earlier, as you all are aware, that the powers of the court under section 9 and section 17 were very different. The arbitrator had very restricted powers under section 17, and the court had a very wider power under section 9. And that led to a whole lot of section 9 proceedings for interim measures interim measures of protection in court while the arbitration was going on. And to avoid that, and to avoid the repeated attempt on the part of parties to approach court pending an arbitration, section 17 was amended, and the same powers which were conferred on the court under section 9 were conferred on the arbitrator also. So the powers of the court under section 9 and the powers of the arbitrator under section 17 are almost the same now. And that sort of reduces the requirement of a court parties to approach the court while the arbitration is on. Now, they also gave earlier under section 17, the order of the arbitrator under section 17, there was no mechanism of it being enforced. But now it is said that this order of the arbitrator under section 17 will have the same effect as an order passed by the court. So that reason of the parties coming to court, or the apprehension that it's better to go to court than go to the arbitrator, because if we get an order from the arbitrator and the other party does not comply, then it's no purpose. So that was the fear earlier. So that has sought to be done away with. Section 9 now expressly clarifies that the parties can come to court only if the remedy before the arbitrator is not efficacious. Now you would say, how can the remedy before the arbitrator not be efficacious when the same powers are conferred on the arbitrator under 17? These could be situations where you require urgent relief even before the arbitrator is appointed, or there could be a situation where an arbitrator is not available, an arbitrator is unwell, the arbitrator is traveling. There could be so many situations where you require some urgent relief, but you are not in a position to get that relief before the arbitrator. In that situation, you can come to court under Section 9. And in the earlier regime, a lot of parties used to get relief under Section 9 and thereafter take no steps to appoint an arbitrator. Though there were judgments of the court which says that if you file a Section 9 proceeding, you must thereafter take steps to appoint an arbitrator. Effectively, parties were not doing that. And their Section 11 was amended to say that if you do not take steps to appoint the arbitrator within 90 days of any order being passed under Section 9, then any relief granted under Section 9 of the Arbitration Act will stand vacated. And there's a Karnataka High Court judgment which seems to suggest that the relief will get vacated automatically without any further order from the court. And that's important because the order of the court under Section 9 before the arbitration commences is intended to be a pro tem order to ensure to protect the rights of the parties before they can approach the arbitrator. Because the idea is that as early as possible, you should constitute the tribunal and thereafter go to the arbitrator and raise all disputes. One more important provision under Section 9 is now it is made applicable even to foreign seated arbitrations. So this was a great deal of controversy which went on prior to the 2015 amendment because there were judgments of Bhatia International. Earlier, there was nothing to show that Section 9 proceedings would apply to foreign seated arbitration because Section 9 is contained in Part 1, which is applicable only to arbitration seated in India. And Bhatia International sought to, in effect, expand the horizons of the Act, said Arbitration Act 1996 was a badly drafted piece of legislation, and in effect went on to the extent of holding that the entire Part 1 would also apply to foreign seated arbitration. That led to utter chaos. And that was one judgment which led to arbitration having absolute hindrance in India for years together. And that drove back arbitrations in India by a number of years. Following Bhatia International, venture capital went on to even hold that Section 34 was also applicable to foreign seated arbitrations. So that, and finally that ended up with Balco, where it was held that it is not applicable to foreign seated arbitrations unless the parties expressly agree. But there also in Balco, the Supreme Court divided it into two categories and says this will not apply to agreements which were entered into prior to this judgment, but this will apply to agreements entered into after this judgment. So the 2015 amendment tried to clarify this and made Section 9 applicable even to foreign seated arbitrations unless the parties have expressly agreed to exclude the applicability of Section 9. And the Bombay High Court judgment holds that this agreement should really be an express judgment agreement. Though there is a Delhi High Court judgment, I think, which I mentioned in the note, which seems to suggest that it need not necessarily be express, but it can be made out from the other provisions of the agreement. I think that is mentioned in my note. Yes, that is, Delhi High Court has taken a contrary position in view of the omission of the word express. So the Delhi High Court has gone to hold that the agreement to exclude Section 9 can even be implicit and implied from the other terms of the agreement. So that's the also important one point, that the Bombay High Court there are two judgments, one of Justice Kulkarni and thereafter another judgment of Justice Patel, which hold that Garware wall rope, the observations in Garware wall rope are restricted only to Section 11 proceedings and will not be applicable to Section 9 proceedings. Because the full bench of the Bombay High Court was applicable both to Section 11 and Section 9, and that the Supreme Court judgment in Garware wall rope was only a judgment in the context of Section 11. These are both judgments which hold that despite a document not being adequately stamped, the court is entitled to grant interim relief to the parties under Section 9 of the Arbitration Act. So these are two very important judgments of the Bombay High Court, which I mentioned in my note. So that is the situation under Section 9 of the Arbitration Act of as amended in 2015 and 19. The next important provision is the provision of Section 34 of the Arbitration Act. Now, Section 34 of the Arbitration Act, as you all are aware, was one of the most litigated upon provision, which was interpreted time and again. And though the 1996 Act was intended to give a very wide, very narrow ambit to the challenge under Section 34, various judgments starting from ONGC versus Saw Pipes went on to expand the grounds of challenge to such an extent that at times it became like a virtual first appeal. This started with the judgment in ONGC versus Saw Pipes, which brought in the concept of patent illegality, which was not expressly mentioned in the 1996 Act. This was met with a great deal of criticism, but the judgment was never effectively disturbed, and this judgment was followed and repeatedly followed, though the Supreme Court in certain judgments thereafter did say that these are issues which have arisen out of ONGC versus Saw Pipes, but the bench said that I am bound by ONGC versus Saw Pipes and therefore followed ONGC versus Saw Pipes. That led finally to the judgments in Associated Simmons, Western Gecko, which even brought about an element of Wednesbury unreasonableness within the element of challenge to an arbitration award. Now, that view of Wednesbury unreasonableness is really applicable more to administrative actions, etc. But this was brought in also in the context of an arbitral award. And these judgments really brought about a expansive challenge to an arbitral award, whereby just about everything was being argued under Section 34 of the Arbitration Act to challenge an award. This was sought to be undone by the 2015 amendment. But I always had a thought, and that was also a part of my dissertation for my PhD, where I had always said that the problem with the Indian statute was that we legislated blindly following the ancestral model law without realizing our grassroots problems and without realizing our difficulties in our structure of arbitrations and the court proceedings. If you see the English Arbitration Act, they have made a great deal of deviations from the ancestral model law and molded it to the realities that exist in England, which we never did. It was ancestral model law was a law which was formulated in as a model law to be followed by a large number of countries. Now, we cannot forget that domestic arbitration in India at times is at absolute grassroots levels. We have sometimes very basic merchant associations which run arbitrations, where neither the arbitrator nor the parties are very familiar with fundamental principles of law. And sometimes it requires a little element of judicial scrutiny. And this found place effectively in the 2015 amendment, whereby for the first time, the legislature sought to divide the grounds available for challenge to purely domestic arbitrations, that is, for arbitration between two Indian parties, and the grounds of challenge in relation to an award passed in international commercial arbitration, where one of the parties is an international is a foreign party. The idea really was that it was presumed that the parties who have contracted with one another, where an Indian party has contracted with a foreign entity, both the entities are very sound and are very competent to be conscious of their rights, and their arbitrations would really be conducted by a better set of arbitrators who will be more familiar with the process of law. At the same time, for a domestic arbitrations, purely domestic arbitrations between two Indian parties, an additional ground of challenge was provided, and that was of patent illegality. Now, patent illegality, having realized that the courts have themselves stretched and brought about patent illegality some way or the other, patent illegality on the face of the award was really brought into the Section 34 only for the purposes of awards between two Indian, in an arbitration between two Indian parties. But it is at the same time clarified that an erroneous application of law or a reappreciation of evidence was not permitted while assessing patent illegality. So patent illegality does not mean that you go into evidence and read evidence and reappreciate evidence, or that though the arbitrator has understood the law correctly, the arbitrator has applied it erroneously, that these are not patent illegalities. What will be a ex facie patent illegality? An ex facie patent illegality will be where the arbitrator has relied upon a repeal provision of an act. So that is a patent illegality. But I must tell you that these terms, patent illegality and all, are very fluid terms, and very often we find in courts that an argument is made and it's tried to fit it, an attempt is made to fit them into a patent illegality. We all do it in our ways when we appear for the petitioners. But if you see the recent trend of courts, we find that the courts have been honoring the spirit of the 2015 amendment, and the interference by the courts in the recent line of judgments that we have seen have been relatively lesser. If you see a series of judgments passed by Justice Gupte when he was taking up the arbitration assignment, there are a series of judgments where he has read these amendments and has declined to interfere on the ground that that tantamounts to a reappreciation of evidence. So that is a very important provision which has been brought in under the Arbitration Act in Section 34. There is the fundamental policy of Indian law, which is used in Section 34, public policy and fundamental policy of Indian law, which is used in Section 34. The same term is used in Section 34 as well as in Section 45 regarding enforcement of the arbitration awards. But the difference in the language is that while Section 34 uses the term contrary to public policy, the award being contrary to public policy of India, Part 2 uses the words that the enforcement is contrary to the public policy of India. So really, there is a difference between the award being contrary to the public policy of India and the enforcement being contrary to the public policy of India. And these are issues which have been gone into by the courts. And the courts have held that the term public policy of India and the fundamental policy of Indian law, as occurring in Part 2, have a much restricted meaning than in Section 34 or Part 1. And that was also held in the judgment in the case of Renu Sagar. But after the ONGC versus Sawpipe judgment came in, an argument was made that now that ONGC versus Sawpipes has defined public policy of India, That definition would also be applicable to Part 2, and that the restricted definition given by the Supreme Court in the Renu Saga judgment for Part 2 awards is no longer good law. But the judgment of the Supreme Court in case of Lal Mahal said ONGC versus Saw Pipes was a judgment, and the observation in ONGC versus Saw Pipes was restricted only to Part 1 awards and would not be applicable to Part 2. So we reverted back to the principles laid down in Renu Sagar's judgment. And these are issues which have been gone into a series of judgments by the Bombay High Court, some of which are referred to in the note. So this is the broad ambit of Section 34. The Section 34 and each of these provisions can actually require one session if we have to deal with it at great length, but we do not have that luxury. Then one more important provision which was introduced was Section 29A, which was, and you all would have made these applications in court, that a time limit was fixed of 12 months for completion of arbitrations. Now, this has been amended in the 2019 Act for providing, earlier it was 12 months from the commencement of the arbitration proceedings, that is when the arbitrator entered reference. But now it is 12 months from the completion of pleadings, which are to be done within 6 months. So it is effectively 6 months for completion of pleadings and 12 months thereafter. At the same time, now for international commercial arbitration, the words used are that it should be an endeavor to complete it within 12 months. So it was recognized that very often in international commercial disputes, the issues are much more complex and it may be difficult to conclude it within 12 months. And therefore the words used now are an endeavor should be made to conclude the arbitration within a period of 12 months. Now, there are certain issues in Section 29A which lead to a great deal of complexity. They talk of the power of the court to reduce an arbitrator's fees, or if the court finds that the arbitrator has delayed the proceedings, then there would be a situation where the court can remove the arbitrator. Now, these would all be situations where an arbitrator necessarily has to be a party to the arbitration proceedings under 29A. So if a party seeks a removal of an arbitrator or a substitution of an arbitrator on the ground that the arbitrator has delayed the proceedings or a reduction in the fees of the arbitrator, then effectively he'll have to implead the arbitrator as a party and the arbitrator would have to be heard. And that has been now expressly provided for, that the arbitrator will have to be heard under section in the 2019 amendment. So these are situations which have led to a great deal of complication. There was never an intention that the court will regularly scrutinize the progress of an arbitration. But the reality in India was that arbitrations went on for 4 years, 5 years, at times even more than that. And 29A, which the courts have been granting liberally, has really had a good effect on arbitrations, because both the arbitrators and the parties are conscious that they will have to go to court and seek an extension, and the court may question them as to what progress has taken place in the arbitration. So as a mindset change, the provision under 29A is bringing about a little element of expedition in arbitrations in India. These are usually provisions which are never found in a statute, in a modern day arbitration statute in any country. But as I said, that arbitrations in India had at times deteriorated to such an extent that we required, to some extent, a statutory institutionalization by way of a legislation. Most of these provisions, which were included by the 2015 arbitration, including provisions regarding timely completion of arbitrations, including the provisions for ensuring an impartial arbitrator are usually provisions which are found in rules of arbitral institutions and not in a statute. But since in India, institutional arbitration had not developed and most of the arbitrations were ad hoc arbitrations, in that situation, what really happened was we resorted to what I usually call a statutory institutionalization. So all the things which are found in the rules of an institution, we have tried to incorporate in our legislation. There are very few statutes in the world where you will find such provisions. But that's where it is. As I said, the situation in India, the reality of arbitration in India was such that it required these kind of measures being taken. Another important provision under the Arbitration Act is Section 14 and 15, where there are now provisions, there are two schedules added to the Arbitration Act, which are a replica of the provisions of the International Bar Association of the qualifications required of an arbitrator in order to ensure the appointment of a fair and impartial arbitrator. So what really the situation earlier was that various institutions and bodies were appointing their own employees as arbitrators. They were employing their relatives as arbitrators, and a whole lot of confusion was taking place. Wherever interested parties were acting as arbitrators. So Section 14 and 15 now, Section 12 onwards, various conditions were put whereby, and the two schedules were added. One schedule provides for an absolute disqualification, that if you fall in one of those categories, you are absolutely disqualified from acting as an arbitrator. The second schedule provides that if you fall in those categories, you must make a disclosure to the parties. So a part, one schedule is a non-waivable objection. If non-waivable, if you fall in that category, you cannot act as an arbitrator. And the judgments now say that if you fall in one of those classes, and if you have been appointed as an arbitrator, then you need not go to the arbitrator and make an application asking him to recuse himself. You can directly come to court seeking a substitution of the arbitrator under Section 14. So it's open for you to make that application to the court directly, saying that the arbitrator is de jure unable to perform his function, he's disqualified, and therefore please remove him and appoint another arbitrator. And the courts have been entertaining these applications directly. And there are a series of judgments which say that it is not necessary for you to go to the arbitrator, but it is open to you to come to the court directly. So I guess these are the broad nature of the changes which have been brought about by the 2015 amendment. And if there are any queries and if somebody wants to moderate it, then I'll be happy to discuss that rather than answer that. Neeraj?
Yes, sir. I will like to request everyone, if they are having any question, they can drop the message. Accordingly, Birendra sir can give the answers if possible for you, sir.
Let's see if there is any question.
Anyone, any questions?
There is a query which says, is there any limitation for filing application under Section 29A? Now that I have already, in my note answered, that though there is not no limitation, the court has clarified that it should be within a reasonable time. Now, what is reasonable time will really, as they say, depend on the facts of each case. But it's not that after 29A, you come after 2 years and go to court and say, now, replace an arbitrator or, extend the time. So it should be within a reasonable time you go to court. And another important, finding of the court has been that in Section 29A, the court will only consider the aspect of delay and not other aspects. In 29A application, you cannot start going and saying that this arbitrator is biased, so remove him and all that, and try to bypass other provisions of the Arbitration Act. The court will only see whether there has been a delay, and if so, who is the cause of the delay. So that is one answer. which would be there to one of the queries.
There's one more question. Does the
Uh,
fresh
in NBFC standard agreements, unilateral clause of arbitration, is that still valid for appointing an arbitrator? No, it's no longer valid because there is a Supreme Court judgment now which says that this is not valid anymore. There is a judgment of the Supreme Court to that aspect, to that effect. Has the scope of 34 changed recently? Are the courts tilted towards first admitting any arbitration petition? I've already answered that to some extent, that saying that my experience has been that the courts have been much more restrained in entertaining 34 petition after the 2015 amendment. Reason of substitution under 14 and 15, I've also dealt with that. Can you express your views on the amendment 2019, how it helps in making India an international arbitration hub, whereas it restricts the involvement of foreign arbitrators? Now that really, I can answer this, but that's not really within the scope of our topic. But yes, the 2019 amendment has sought to institutionalize the arbitration, and the whole aspect of appointment of arbitration has been shifted to institutions, and there is an arbitration council formed. So there is a lot of criticism to the 2019 amendment, and in its attempt to encourage international arbitration, I think we'll have to restrict that to another day. There are too many questions flowing in.
So we can do one thing. If they have any question, they can drop the email to you or any message in the group.
I can't answer all so many emails. So that will be difficult. But if you all have any queries, maybe we can collate it and answer it. 1 second, let me see. I've also got some. Okay, there is one query that will, every time there is a new invocation, will that lead to a fresh cause of action for section 11? I don't think that is possible. It's not possible that every time you make a new invocation, so there was an invocation, after 3 years you make a fresh invocation. I feel there is a judgment to this effect, but on a first blush, I don't think that is possible to do that every time there is a fresh invocation. So what happens is you had invoked an arbitration 5 years back. You did not file a section 11. So you invoke it again now, and thereafter you go and go to court, looks difficult. So what do we do, Neeraj? Do we stop here?
Yes, sir. We can stop here, sir. Thank you so much, sir.
Yeah.
And
thank you so much. And I'm sorry, as I said, I prepared not for a very extended session because I was told a 35-minute session, but I think we have covered
across 40-45 minutes, sir.
Yeah. So thank you so much for suffering me, and stay safe. See you all soon.
Yes, sir. So Neeraj, sir, Associate Advocate of Law Chamber of Siddharth Moraka and the Law Club Telegram group would like to take the opportunity to place on record our heartily thanks to Dr. Birendra Saraf, Senior Advocate, Bombay High Court, for the lecture on the effects of Amendment of Arbitration Act to Court Proceedings, a critical revolution, and look forward to have at least one lecture by you every month, sir.
I'll be happy to share anything here.
Yeah. Again, thank you for the fantastic upgradation for the lawyers' knowledge. We hope to empower lawyers and serve the nation. We also extend my thanks to the Law Club friends for the enormous cooperation in the organization of this event. And sorry for the inconvenience to everyone. And be safe and be happy and be healthy.
Thank you.
Thank you, sir.
Thank you, sir. Thank you, sir.
Thank you.